Hello, good day, everyone. My name is Ron Velasco from International Trade Council. So, we are just waiting for other participants to log in. It's 1 p.m. UK time. So let's just wait for others to log in. So we will start probably after 5 minutes. Thank you. Hello.
Hello?
Yes, hi. We can, so there's some attendees right now, but just to inform you, we have 36 attendees for this webinar. We can start now, and we will just wait for other attendees to log in. And then just to inform you, this webinar is recorded. So those 36 registrants, we can just send the recording to them and the presentation as well. But right now we can start the webinar, and then we will, while you are speaking, we will just let other people to log in.
Okay.
So we can start now. We have Mr. Thomas Moore right now, who will going to discuss about intellectual property in United Kingdom. So I will give him the mic right now, and he will start the presentation. Go ahead, Tom.
Thanks. Hi. So yes, I'm here to talk about intellectual property in the United Kingdom. For your entertainment and information, there's a photograph of my face, some of my qualifications, my contact details if this leads to questions which you don't ask during the presentation or you see it later. So that's the end of that slide, really. That's the fun of that one. So what is intellectual property? This is the first question that you have to ask. And the dictionary definition is creations of the mind. So that's inventions, literary, artistic works, design, symbols, names and images used in commerce. Typically in our country, we see that as copyright, design right, trademarks and patents. We're not covering patents today because they are a separate area all of their own because of the size and breadth of that. But IPR goes further, so it includes confidential information and know-how, things that evolve on websites, domain names, database rights, and there is a tie-in with both the general data protection regulation and the transfer of personal data internationally there. Business names, goodwill and unfair competition. And of course, in England, we have a multiple system insofar as we have a common law jurisdiction and we also have statutory legislation. So some of those cross over. So trademarks have a unregistered right, as do designs, but copyright is probably the most simple of rights. So we'll take that one first. So the first right is copyright. There's automatic protection for copyright, and it covers pretty much everything you do or use on a daily basis. There isn't much that isn't protected by copyright. And the definition would be anything that you do to express your ideas in a tangible format creates copyright, and that right is automatic and it exists upon creation of it. That's really good news because it's free. You don't have to do anything or pay anyone for the copyright to come into existence. But that then also leads to its downside. So because protection is automatic and they arise with the creator will often remain the owner of the right. So for example, if I ask somebody to go and take a photograph for me, that photographer is the owner of the rights in that image unless and until they send them over to me. So even the delivery of the photographs by email or on a disc or in a printed format will not mean that I am the owner of the rights. I might have an implied license, but I'd have to prove that I had that implied license by a chain of correspondence that goes back in time. So proof of ownership, or if you're the creator, proof of creation is absolutely essential for copyright. If you try to enforce your right against another party, this is the first question, which is, are you truly the right owner? Contract is the simplest way, and in that respect, treating copyright like any other right, or indeed any property, intellectual or otherwise, ownership of it by virtue of a deed, which is a legal transfer of title, means that you can then enforce those rights. You have to bear in mind, however, that because copyright comes into existence automatically and therefore there's no cost to it, its enforcement is difficult, not only because you have to prove that you are the owner of the rights, and you have to prove that your rights were created as of a set date and time, but you will also be limited by your enforcement because copyright only protects against copying of your work. So if you've designed a logo and the work is copied and it's wholesale copied, i.e. it looks identical, then that's a copyright infringement claim. Traditionally, if there were variations in the work, then the other party would say, well, I've taken inspiration from what you've done, rather than infringed it. Having said that, more recently, we've seen case law like White Bicycles and Haas Sponsorship Company have been involved in complicated matters which involve both trademark and copyright law. And we've seen that the inferment and copyright is that you can have something which looks similar rather than the same, and that could be infringement. Ultimately, however, that will always turn on the facts. So Copyright, in summary, very easy to come across because it's being created all the time. You have to be able to prove you're the owner of it, and how you do that is very difficult. Traditionally, people have recorded the delivery of documents by post, or they stored them with a third party and had a receipt for the storage of those items. But essentially, anything you can do if you were in court to show that you created those materials as of that date and time, or if you weren't the creator of those materials, that the creator has assigned the rights over to you. That's absolutely essential. Otherwise, you've got nothing to enforce. Often confused with copyright is design rights. And there are two forms of design right. There is a registered design and an automatically occurring design right. And this goes back to our jurisdictional system having both statutory and common law. So the statutory system is better. There is no two ways about it. You can file an application with the United Kingdom Intellectual Property Office for £50. Your examination is not substantively examined, so an examiner probably won't even bother to look at it. So if you file it, it will be registered. You have 12 months from the date you first make your design public anywhere in the world to file an application. You have to show that you have a tangible record of the design, but it would be very difficult, I think, to file a design where you don't have a tangible record, because you'd have to have a recording of it somewhere already. And indeed, to file the design application, you would be making a recording of it. And then they last for 25 years. So they're due for renewal every 5 years. The key here is that the examination is not substantive. So you can file anything as a design in the United Kingdom and it will be granted, most likely, design registration. That process takes less than a month. However, it is then down to you to police the design register and to enforce your design against others. Now, because of the non-substantive examination, that does mean that quite often, and indeed, if you look at the register to date, there are lots of designs on there which are technically unenforceable designs, and they are only filed on the basis that they could try and enforce them. Many companies file lots of design registrations simply so that they can use them in letters of correspondence and in reference to point out that they have lots of intellectual property rights. And you can successfully enforce an unenforceable registration because the party that receives the notice may simply be in fear of your registration in your design. It is not the safest system and it is not a recommended system, but it does take place. In addition, design registration is probably the cheapest intellectual property right to obtain, which is a registered right, because the filing fee at £50 is a sliding discount, meaning the more designs you file simultaneously, the less you pay per filing. And the designs do not have to be connected. So you can file a design for a chair and a table and wallpaper all at the same time. Also worth a note is the UK registered design system allows you to protect things which are surface pattern or the layout and pattern of a particular item. So for example, I gave wallpaper as one such example, but for example, you could have wallpaper as a design registration, and you could even have the layout of the LEDs in a screen at a microscopic level as a registered UK design. On the other hand, you do have an automatic right in the UK, which is called the UK design right. The benefit is automatic protection, but it has all of the considerations of copyright. So you have to worry about who created it, when it was created, whether or not you have ownership. Now, unlike copyright, where ownership stays with the creator unless and until there is a transfer to the contrary, design rights, which arise automatically after October 2014, transfer automatically so long as it is a commissioned piece. So if you ask a party to design a product for you, the design rights in that product will transfer to you so long as the commissioned piece took place after October 2014. You have to remain to consider all of the other issues around copyright, so proof of ownership, proof of date of creation. The limited scope is also very, very narrow. So if you were to have surface pattern, for example, that doesn't apply. If you were to look at minor variations in a product, that won't apply. If you're looking at something which is the internal workings of an item, that won't apply. So your UK design right is a very limited right. It is always a handy backstop, but registration is definitely preferable. So for latter reference, I provided a comparative table of some of the key issues between UK design rights and UK registered designs. I would always recommend my clients seek registered design, especially given that the costs are so low and that enforcement is relatively easy. Once you have a registration of a design and you can prove you're the owner of it, the enforcement is down to you. And most of the time, sufficient enforcement, bearing in mind that you're not enforcing one right, but you're probably enforcing many, involves just not one registered design number, but many registered design numbers, at which point you're showing a portfolio of your rights, and you're more likely to have a successful outcome. One of the things to consider when filing UK registered design is the appearance of the design in itself. If your product is in prototype, you will need to consider whether you're going to file another design registration once the prototyping is complete. If the product is confidential because its appearance is going to be new to the marketplace, then filing a design is not a good idea. If your design has variations, then you may need to file multiple designs. And if there are elements of your design which you do not think influence the overall appearance of the product, then you may not want to include those at all. Apple very cleverly, shall we say, filed rectangular images for their iPad when they first launched those. And although the designs were ultimately not relevant to the case outcome, it's been shown that there is an appetite in the design filing marketplace to file design applications which remove non-necessary or non-identifying items from designs. Having said that, I think it's probably given the cost an opportunity to file multiple designs rather than try and cut the cloth accordingly. Moving on, we have trademarks. So trademarks are probably the most useful of intellectual property rights when it comes to reputation brand management. They shouldn't be viewed in isolation. I'll come on to the intellectual property viewment in isolation shortly, but trademarks as a concept protects anything which identifies your brand, and your brand is your brand because it's not another brand. So what I can say by that is that you can have obviously words, logos, colors, sounds, even smells are all capable of registration with the United Kingdom Intellectual Property Office. However, you will struggle to get B, C, and D registered with the UK IPO. That is mainly because case law has shown that colours are very difficult to have an essential badge of origin function. Sounds likewise, although in some circumstances can do. So the direct line jingle and the Intel jingle have both been capable of enforcement as trademarks. Smells, while a chemical formula as recorded could be protected by trademark, and we have had that in the past. Difficulty around smells comes with enforcement because a different chemical combination can create a same or similar smell. And if you're in the marketplace for creating a particular odor, you're probably going to be looking to differentiate yourself by creating something which is distinctly different. And if you create something which is the same, you're more likely to have a passing off claim, depending on the approach of the packaging. So and just very quickly to divide those two things up, A is the absolute yes for trademark registrations. B, C, and D are all capable of registration. However, when it comes to passing off, A and B are usually key. By passing off, what I'm talking about there is reliance on a trademark which is not a registered trademark. So again, just like design, you have trademark rights which come into existence automatically as you use your brand in the UK and you build up your goodwill in your business. The rights will rise automatically. However, enforcement of those rights will have to be done based on what's called a passing off claim, which is a common law tortious claim. It is not an easy claim to run unless you have a huge reputation in the marketplace and you have budgets that sort of suit that. So in terms of running a passing off claim, the average cost to a passing off claimant is around £200,000, whereas, as we'll see in a minute, the trademark filing fees at the UK IPO are 170, and enforcement fees can be much, much less because you can enforce through the UK IPO or through the Enterprise Intellectual Property Court. But the key thing to remember is in the UK, predominantly words and logos are capable of registration. You can obtain protection for colours, sounds and smells, though they are of limited use. And this is the three guiding rules for trademark registration. So they must be distinctive, not be descriptive, and not be misleading. Now, distinctive is always a tricky one because often that is going to be a subjective point. What is distinctive to one may not be distinctive to another. And there is available for public inspection an examination guideline provided by the UK IPO, which you can read through, which talks about what is to be considered distinctive and what is not. The usefulness of that is limited. There is an amount of fig leafing that goes on in the UK where you might take a mark which fails on point B and C, and you include a colour or a stylization or an element of a logo so that it acquires some distinctiveness. However, descriptiveness and being misleading are the two biggest foibles for trademark applications. So descriptiveness seems to be something which is increasingly common in the trademark market as more and more people file their own applications. And descriptiveness is, I think, the most obvious example would be to have, if you were making a soap and you called that soap cleaner, well, that cleaner, the word cleaner is describing one of the outcomes of using the soap product. And given that the trademark is essentially a government endorsed monopoly over a particular brand for a particular goods or service, you shouldn't be allowed to prevent others from using a descriptive term in relation to their product. That's why descriptive is such an issue, and we see it more and more because the trademarks market is frankly becoming crowded. The way to avoid descriptiveness is, like I say, there's fig leafing, although the UK IPO are becoming aware of that and they're becoming closer to the law in terms of interpretation of whether or not it should be allowed, but also including elements outside of fig leaf. So if you were to stylize your mark wholeheartedly or use your mark solely as a logo, then those two routes might be a best route to go around being descriptive and adding distinctiveness. The point on C, not misleading, it comes and goes, the misleading point. To be honest, the biggest issue here is whether UK IPO take a public morality point of view and they think that the mark is either rude or prima facie incapable of registration because it breaches some other rule like Article 40 of the Paris Convention, which protects the registration of crown and crown-like symbols. So there are other things which you cannot ever register as a trademark. So the red cross, for example, the Olympic symbols, and the aforementioned crowns. So one thing to note is if you're including anything like that, so if you've got some sort of royal insignia in a mark, you are going to struggle to achieve registration at the UK level, and they will ask you to defer to the Knight Garter of the Realm. That's very expensive. So you would need permission from the owner of the shield or crest or crown which you're filing for. And of course, slogans, because they fall into being descriptive most of the time, or they're non-distinctive, or they're simply not a badge of origin in the true sense, they're not prima facie capable of registration. What I mean by that is you would have to show that you have educated the marketplace and you have acquired distinctiveness for a slogan to be capable of registration. That is the reserve of entities which will spend hundreds, if not millions of pounds on marketing budgets. And there are few and far between examples of true slogans which are registered as trademarks. So there is a push in the marketing world for the inclusion of a trademark inside the slogan, which we've seen in the last 5-7 years. So that's what's capable of protection by way of registration at trademark level. And this is the detail of that. So £170 is your filing fee. That includes your first class. And then it's £50 for every additional class. The UK used the NICE classification guideline system. So it's 1 to 34 for goods, 35 to 45 for services. There is no limitation on the number of terms inside each class while building out a specification, although quite often you'll find that people filing for you, so trademark attorneys and lawyers, may charge you on a term-by-term charge. There is a substantive examination and there is a notification that will be sent to similar right holders. However, the UK IPO currently only notify UK trademark rights owners when they cite an earlier mark when you file your application. That means if you file an application in the UK and an earlier right is identified on the register of either the EU IPO or the Worldwide Intellectual Property Office, excluding where the Worldwide Intellectual Property Office cites the UK right, the UK IPO do not write to the right holder. They only write to domestic right holders. Once they've written to them, there is no refusal on the basis of the identical or similar mark. So unlike other jurisdictions like Australia, where you might struggle to get your application through, the UK will allow the application to proceed to publication, but they will have put that party that they've identified on notice, unless, of course, they're an EU-only party. At that point, you have your 2-month publication period, and the application can take around 6 to 8 months to achieve registration because of the examination period, and there is a general administrative period at the receipt of the mark and also post notice of publication. So you'll be told that the mark is to be published, and there will probably be maybe a month's wait before it actually is. But the key thing to remember in the UK is that it is a first come, first served system. Earlier rights win, and that is why there is a review of the existing database. So you need to get your marks filed as soon as practically possible. If there's a mark which is already on the register before yours and the owner of that mark takes umbrage at your application, then the ordinary course is for them to issue some notice to you of their umbrage, and they would then probably file a TM7A, which gives them an extra month and extends your publication period by an extra month for them and potentially you to come to some sort of understanding over what might happen in relation to the application. Note that the 1-month extension only applies to you as the person who's filed the application and they as the people who've taken umbrage at your application. Also worth noting is that around 85% of UK trademark applications proceed through to registration without issue, other than those absolute grounds which I covered in the previous slide. So what I'm saying is 85% are unopposed. Of those which are opposed, we see around 7 to 12% achieve registration in some form or another, which shows that there is a conciliatory or coexistence-like approach in the UK, which is good because it gives you the opportunity to obtain some form of registered protection for your trademark. So those are all the forms of rights which you can file applications for, excluding patents, which we're not covering. And we need to then come on to how we're going to go about enforcing these rights. So there are, broadly speaking, 2 routes of enforcement. If you have a registration and there is a right which is being filed in that same register, which is monitored by the United Kingdom Intellectual Property Office, or at the moment, the European Intellectual Property Office, then you may take action via that office using your registered right. Each action will depend on the nature of the right that you have, the issue at hand, and the type of action you wish to take. So, for example, if a right pre-exists on the UK register and you're filing an application for your brand, and your brand is already registered on the UK trademark register by some third party who you have had previous dealings with, then it may be that you need to take bad faith action against that original application to have it stripped from the register so that your application can be filed and proceed through to registration. The UK IPO have some very good online guidance about the basic actions that they can take, but most of those are focused around actions that you can take in relation to marks which are being newly filed, because as I just said, it's a first come, first served system, but there are rights which you can rely on, and the UK IPO do have a bona fide intent requirement when you file an application. So if it's a bad faith application, they will entertain applications for those marks to be struck from the register. Other than that, all other enforcement will take place through the standard UK court system. And we have an intellectual property court called the Enterprise Intellectual Property Court. It does have a claim limit of £500,000, and the civil procedure rules therefore apply. And civil procedure rule 1.1 is that parties should attempt to resolve a dispute without the involvement of the court in the first instance. So you should, as par for the course, write a letter to or find a way of putting those parties who may have infringed your rights on notice. The only exception is where you are minded to seek injunctive relief. Even then, it shows from case law that it's likely better for you to achieve injunctive relief if you have put that party on notice of your rights and your intention to take injunctive relief against that party before you take the relief. It is quite a bizarre but relatively old-fashioned system of notification is always required first and then taking action after that point. So it's not, for example, like the legislative system in Germany, which allows very quick action to be taken and preemptive filing to be made at court. This is very much the other way around. You should try and keep it out of court for as long as possible. You should show that you're trying to mitigate your own loss for as much as possible. And if you're going to even seek injunctive relief, like the removal of a product from sale or trade, then you would need to put those parties on notice first. If you are taking injunctive relief, you'll need to give cross undertakings to the court, which means that you may be liable for a loss that's incurred by the other side if post-injunction the case doesn't go your way. And a similar thing exists in our Trademarks Act 1994, which says that there's a thing called threat provisions, you could be liable for a counterclaim if your letter before action or your cease and desist notice is so aggressive that it causes the party to stop trading, and then it later transpires that cessation of trade shouldn't have happened because there was no infringement. Then you may be liable to a claim which is a counterclaim based on the threat provisions section of the 1994 Act. So the headline news there is, if you think you're being infringed by a third party, seek legal advice. It is not a straightforward route to go down. Right, moving on, we then have the elephant in the room, Brexit. And I have to say that a lot remains to be unknown, but we do know these two things. So any EU application filed to register for designs or trademarks which do not make maturity before Brexit will fail to achieve registration in the UK. So if you have filed a trademark application at the European Intellectual Property Office today on the 15th of July 2019, that application is examined and then it goes into publication, and that publication period is 3 months. Your application may not finish its publication period until the 1st of November 2019. At the moment, the United Kingdom is due to leave the European Union on the 31st of October 2019, and consequently, your rights in the UK will not exist by virtue of your EU application. That is to say that 27 member states, all member states at the moment excluding the UK, will achieve registration for the trademark in the European Union, and your UK mark, which would exist under the European Union right, will not exist. That means at the moment we are advising all our clients to file simultaneously in the United Kingdom as well as the European Union intellectual property offices, because there is no certainty of achieving registration in the UK for any application filed in the EU at this time. We are also recommending any applications which pre-exist in the EU register and they're not in the UK register in isolation should be considered for a separate filing in the UK right now. The reason for that is post-Brexit, European Union rights will be cloned into the UK register, and the cloning into the UK register will likely cause some issues. As I mentioned earlier, the UK trademark system works on a first-come, first-served basis, and if you have a UK right and an EU right which have different dates of filing but are the same right and have coexisted for this period of time, you will find yourself in an issue where the cloned rights will all carry the same date of carryover, and you'll then have a question over which right came first. If your rights which exist in the European Union are absolutely paramount of importance, if you file a UK trademark application now, you are unlikely to achieve registration of that mark by the time that the cloned mark is carried over from the EU rights by virtue of Brexit, but your filing date for that UK application will predate the cloning date. So any key marks which exist solely on the EU register for any businesses doing trade in the UK should consider filing those applications as UK isolation applications right now. The sooner the better, because it is a first come, first served system. You will also weed out any issues that could arise from your clone into the UK register on the 31st of October or whenever Brexit happens. It's also worth noting that any ongoing opposition or proceedings involving EU rights involving UK rights in the EU will likely fail, because those UK rights will become unenforceable in the European Union. That includes designs as well as trademarks. And at the moment, there is no sort of mitigating circumstance or plan to resolve that issue. And we have seen in a number of cases where we have ongoing opposition or proceeding matters with the European Union, that the attorneys in other countries are asking for an extension of time or a cessation of proceedings, so that there is a period of time during which nothing happens, and then at the end of it, we've left the European Union and the entire matter will be deemed resolved. So there is a risk, if any applications have been filed and you wish to oppose them and they're based solely on a UK right, you may struggle to enforce that right. So likewise, the outcome of that is, if you have a UK trademark at the moment and you want to file in the European Union, file now, because you are never going to have an opportunity to file in so many countries at such a low price ever again. If you don't get the clone of the mark into your UK register, that's fine. And you will also need an overseas attorney. So anybody in the UK looking to file in the European Union will need a representative in the European Union to file that application for them. Obviously, there's a plethora of choices because you're looking at 27 member states in which you could use one of those attorneys. Don't forget the official filing languages of German, French, Spanish, and English continue. But also consider the ability to use the UK right as a springboard into the European Union to get those protective rights in place, so that should you wish to take action in relation to an opposition or proceeding in the EU, you won't be solely reliant on your UK rights, which won't be useful post-Brexit. All of this, of course, is tentative on the basis that we have a scheduled Brexit date of the 31st of October, and the political landscape in the UK is currently in flux. And we do not know for certain who will become the leader of the Conservative Party and therefore Prime Minister. And after that date, once we do know who will be Prime Minister, we don't know if that individual will necessarily be pro or anti-deal Brexit or no-deal Brexit. So all of these things are currently variables. The only certainty is the cloning of the database into the UK as of the date and time of the Brexit arising, and that anything that post-dates Brexit, which relies on a UK right, will likely fail. So that is a very quick run through of the key intellectual property rights which you have in your businesses, which you should be seeking to protect. By way of recap, the copyright is automatic. Registration of copyright is impossible at UK, and therefore you need to find a way of showing that you were the creator or that you took ownership of the rights as of a date and time. Design rights are both registered and automatically arising. If you register a design, then the automatically arising rights will no longer be valid or enforceable. And there is a table that I provided in the slides which show you the difference between those two rights. By and large, we recommend our clients file design registrations given their reduced cost and increased ability on enforcement, because an unregistered design right has all the same caveats of copyright when it comes to enforcement and proof of ownership and proof of control. And then you have trademarks, and trademarks are anything which you could deem to be a badge of origin for your business. And just like designs, there is an unregistered right which we rely on the tortious claim of passing off. That is a difficult right to enforce, and you have to have significant reputation in the marketplace and be able to demonstrate that reputation and able to enforce it. And then we have registered trademarks. Registered trademarks have a number of caveats as to what can and cannot be registered. And once they are registered, they are yours to enforce. They, by the way, continue forever. So once you've filed your trademark in the UK, as long as you renew it every 10 years, it will continue ad infinitum. And then you come to enforcement of any and all of those rights. And the key thing here is not to look at any of those rights in isolation, but to look at them together as one piece, one portfolio. So every business will have copyright, every business will have a trademark, and most businesses will have some form of designs. It is worth considering what all of those are. I would always recommend that a business does an audit of its intellectual property and then identifies what should be included in its portfolio. And out of that portfolio, you should be able to identify what rights should be registered. The registered rights are the rights to lead on in any enforcement action because they are easier to prove in the UK than any of the rights where you have to rely on the common law system of either passing off or copyright infringement or registered design right infringement. In those circumstances, you can couple those rights up, and there is, of course, the ability to take action in relation to all of them. But you have to be aware that where you, for example, have registered a design, then any copyright that exists in the design may be enforceable to a limited degree, but any design right will probably be unenforceable. Likewise, with a trademark, you're unlikely to rely on passing off as well as registered trademark infringement at the same time. But you might have a cherry picking aspect where within your portfolio of intellectual property rights, you decide that you are going to file one of the trademarks rather than, for example, all three, at which point an enforcement action may include both registered and unregistered rights. Most of the time, enforcement, which includes both of those rights, is more successful because it shows that you have a considered portfolio. An enforcement letter before action cost shouldn't be more than around £1,000. And that's a significant saving on taking action through the court system. In terms of Brexit, it's an unknown at the moment, but the key thing to remember is if you don't have a UK trademark registration, then you should consider filing one as soon as possible, and vice versa. If you have a UK trademark registration but not an EU registration, then it's worth considering filing an EU registration right now, whilst we can still have all 28 member states concluded, or probably 27, for the price of one. That is the end of the presentation, the webinar, I have been obliged to provide you with a disclaimer. Obviously, if you do wish to rely on the advice, then it is limited by the fact that it's not distinctive legal advice for any individual. But if you have any questions, I'll be happy to have them. Thank you.
Thank you so much for that very informative presentation. So if you have any questions right now, you can just type into the chat box so that our presenter can answer the question. All right, we're just waiting for their questions. By the way, these slides will be sent to all the registrants for today, and this presentation is also recorded, so we'll also send that information to them. You're welcome. Thank you so much for attending the webinar, Khalid. So let's wait for Adam if he has some question. Okay. Yes, I think that's all for. Oh, let's just wait. Someone is typing. Oh, okay. So Adam, we will be sending the presentation through your email. We have all the email address of the people who registered today. So we will send the presentation in 24 to 48 hours together with the recording. So you will receive that within 24 to 48 hours. Okay. I don't think that it will be uploaded to YouTube, but we will just send you the recording for this webinar. So I guess, okay, so someone is typing again. All right, good. So I think that's all for today. Again, thank you so much for that very informative presentation. And I will also would like to thank you for attending the webinar. Again, my name is Ron from International Trade Council. You have something to say to the attendees, Tom?
No, thank you very much for all of your time. And like I say, if there's questions that arise and they're obviously you're watching a recording of this, then by all means use the contact details on the first slide to get in touch with me.
Okay, perfect. So you all have a wonderful day.
Thanks. Bye-bye.
You're welcome. Bye-bye.